Avoiding probate, the best strategies to save time and money. So we're going to talk about probate, what it is and why it matters in this video. My name is Michael Pevney. I'm an attorney. I am an estate planning lawyer in California. I set up estate plans for California families. Ask an estate planning question in the comments. Follow me for more estate planning information. And if you live in California, it's time to get that estate plan set up. You can set up a time to meet with me for free by following the link in the comments. So first we need to figure out what probate is. So probate is the legal process, the court system that somebody's estate has to go through if they pass away without a will, or actually even with a will, and it is approved of by the court, it's supervised by a judge, and everything essentially has to be signed off on. And probate is needed when assets, property, real estate, cars, that sort of thing, don't have any clear legal transfer mechanism in place. So we're obviously talking about real estate, we're talking about personal property, and we are talking about bank accounts if they don't have designated beneficiaries. Typically, we want to avoid probate for four big reasons: time, control, privacy, and just cost. That's really the big one. So first, costs. In California, the average home to get it through probate can cost about $50,000. Typically that goes, half of that actually goes to me, the attorney. There are executor fees, court fees, things have to get appraised, that sort of thing. It takes a very long time. The average probate in California can easily cost a year and a half, or take a year and a half to 2 years, even if we're just leaving things to one or more children. And it takes a toll on us. So not only are we grieving, but we have to deal with this court system, deal with court appearances, hiring a lawyer after somebody that we typically care about has passed away, just in order to get things passed along to us. So there are several strategies, and I'm going to discuss many of the main strategies to completely avoid this probate process, not having to go to court in order to have assets put in the name of the person that you want without, again, having to go through court. The first thing that we can do, and we can do this with most financial accounts, is designate beneficiaries. So for almost any checking account, savings account, non-retirement investment account, retirement investment account, and life insurance, we're always going to want to have beneficiaries. So that essentially means that when you pass away, that beneficiary goes to that institution, whether it be an insurance company or a bank or a 401k plan. They basically kind of say that this person has died. Here's the death certificate. I believe that I am the beneficiary, and the money is transferred to you, and it is as simple as that. And that is a very simple way, and oftentimes a very good way, to transfer assets without having to go through probate, without having to go through this entire situation, through court. And that is oftentimes, accepting, in my opinion, real estate, a great way to do that. A second way to avoid probate is joint ownership, right? You can put a spouse, a friend, a child's name on a account number. So essentially, when you pass away, the other person, they just now own that home, and that home or that account, and it just passes to them. Now, there are some risks to this, because if you intend this to be your money, if it's owned jointly, the other person has current rights to use it, whether it's that checking account, whether it is that investment account, even if it's a home that's owned jointly, especially if it's owned jointly to people that are not married to each other. That surviving owner, sometimes in situations, especially when it comes to uh, investment accounts and real estate, we need to worry about capital gains taxes as well. So here's an example. If I think it's a pretty bad idea to put a child's name on a home co-owned with you. So there's a good thing in that it avoids probate, but things can get messy when it comes to capital gains taxes. So let's say that A home is purchased for $200,000, and 40 years later, when mom or dad passes away, the home is worth $1 million. This is a very, very common situation in California, in Southern California, in Northern California, everywhere in California. So now what happens is once the surviving joint owner, unless it's a spouse, especially if it is a friend or someone that had to sign for the mortgage, especially if it's a sibling or something like that, there is $800,000 in capital gains. So if the surviving owner wants to sell that home, they are going to have to pay taxes, capital gains taxes, which is a type of income on $800,000. Now, doing the math sort of quickly in my head, we're looking at somewhere in the range of $160,000 just in taxes. So joint ownership, especially if it is not jointly owned with a spouse, can lead to, yes, it is going to avoid probate, it's going to avoid the cost of probate, but the amount that can often be paid in capital gains taxes is going to sort of wipe out any sort of savings of going through that probate process. So what can be done, of course, is to designate beneficiaries on all of those accounts. Some states do allow transfer on death deeds for real estate, so that is always a possibility depending on the state that you live in. California has just started with transfer on death deeds. It is a little bit of a rocky process, and I'm going to mention to you what I think the better alternative is. A third way to avoid probate is you just give people stuff while you're alive, right? If you have a home, you just give it to the kids. Or you just give things to a friend, or you just give money to people. It's something that's relatively easy to do. You don't have to be dead to do it. You do have control over everything when you give it to them. Now, once they get it, it belongs to them. They get to do whatever they want with it. If we're talking about real estate, they can sell the home. They can take out a loan on the home. You don't necessarily have a right to live in the home, but it's a very clean, simple way to get rid of things before we pass away. Now, sometimes we think about gift taxes. Do we have to pay gift taxes? There's actually a massive exclusion because gift tax and estate taxes are essentially the same thing. So for a married person, it's getting close to $14 million, although that is about to change. For a married couple, it is about 28, getting close to that $28 million range. So if we give something to a particular person that's worth right now $18,000 or less, nothing to file. If we do have to file something with the IRS, but there are no gift taxes that are due now. Depends on the size of our estate. If in the future there is a net estate of that range that I mentioned, getting close to $13,000 or $14,000 for a single person, $27,000 to $28,000 for a married couple, then yes, that's going to be excluded. The gift over $18,000 is going to be excluded from that exemption. So we have to be a little bit careful when it comes to giving large gifts. However, estate taxes don't apply to a huge majority of families or people. We're getting into well into the top 1%. Now, in my opinion, for most of the families that I deal with in California, the best way to avoid probate, especially when it comes to real estate, is to create a trust, a revocable living trust. And that has a couple of benefits. First, it of course completely avoids probate anytime, any hassle, and any cost of probate. Second, it avoids that problem of a step up in basis, because if kids or whoever we want to leave that gift to, whether that's real estate or whether that is investment accounts, there is going to be what is known as a step up in basis. So it will not be as if the kids have to pay capital gains tax on that $800,000 in gain. It will be as if the home is worth, as if the kids paid for it, what it is worth on the date of the parent's death. So if the kids wanted to turn around and sell it for $1 million, zero capital gains, in fact. And so this can be in a great strategy, and typically I'm going to advise anybody that owns real estate in California or people that have smaller children, and we want to control how that money is used. So we've got the avoidance of probate, we have the step up in basis for capital gains, we have the control over how assets are distributed. So what's the bad thing about a trust, about a living trust? Because it's going to save time, it's going to reduce costs, and it's actually private. These are private documents that don't have to get filed with any government agency. Now, the con is, yeah, it's going to cost some money to set up. Usually it is incredibly vastly outweighed by the savings that is going to be in probate. Typically, you're going to have a lawyer set that up for you. And that is really the biggest con of it. You're going to have to think about some serious decisions that involve your own passing away. So in this video, we have talked about what probate is, how much it can cost, and several ways to avoid it. So that can be naming a beneficiary, owning things jointly, giving things away before you're gone, and in my opinion, for most people in California, setting up a trust, a revocable living trust, and placing real estate and potentially other accounts into that trust. Once again, my name is Michael Pevney. I am an estate planning lawyer in California. Please like this video, ask a question in the comments section. I'm often able to reply to them. And if you live in California and you're serious about setting up an estate plan, you can set up a time to meet with me for free. You can find that either on my profile or in the description of this video in order to do that. So I appreciate your time. Thank you for your attention, and I'll see you on the next one.